Counsel, were any of these questions, except the constitutional question, decided by the D.C. Circuit?
The D.C. Circuit, in its stay opinion, relied exclusively on the sort of
notice and an
property interest
opportunity to
argument.
be heard. That's what it said the Constitution required, correct?
It said that, yes, it said there's
All
a
right.
property interest in this office under Loudermill.
That's the only issue it addressed. It did not address all of the things you've talked about today, what the definition of cause is, including whether it includes pre-office conduct and how much or what nexus there has to be between pre-office conduct and post-office conduct. One could imagine that what would constitute for cause during office would be different than what would happen pre-office. Even yourself below said if something was known before confirmation, you likely can't rely on it. You haven't quite said that up here, but logically, pre-office has a different temporal connection. Then the court didn't address whether the president's determination of cause is reviewable and under what standard. Ultravirus seems to me to be whether or not another, and that's what all our cases have ever said about ultravirus situations, whether another entity, another adjudicatory entity, has jurisdiction or we do. And 3, whether Cook has a right to notice and hearing under the statute and what that means, and what remedy, if any, Cook can seek now or finally in the case. You ask us today in this emergency application to provide, to finally decide these issues. I want to know why. Meaning, the president, by your own admission, cannot fire someone for disagreeing with his policy choices. You've conceded that, correct?
Correct.
All right? So it's not as if keeping her is going to thwart any right he has to run the department, because he has none. He's conceded that. On policy, he does not. Now, it's not as if she's been incompetent, negligent, or committed malfeasance while in office. This is something pre-office. So keeping her in office is not causing an immediate harm to the agency. Number 3, we know that the independence of the agency is very important, and that independence is harmed if we decide these issues too quickly and with not due consideration. So waiting, to me, to have at least the lower courts look at these issues first makes the most sense to the public's confidence and to the world's confidence about the due process of law. Explain to me why the president's harm is greater than the public's, greater than the Federal Reserve, who deserves to have people acting that have been in office. And number 3, why we should disrupt, as we said in Wilcott, the disruptive effect of repeated removals and reinstatement of officers. Why shouldn't we wait till the end of this case, where all the issues are clear and where we make a final decision as to whether she should have been removed or not?
Let me start by addressing that last point. We are seeking a stay of an unprecedented preliminary injunction restoring a principal officer of the United States after being removed by the President of the United States.
112 years, and it's unprecedented that any Federal Reserve officer has ever been removed. So the unprecedented nature of this case is a part of what the President did, not what Ms. Cook did.
I think that statement has to be qualified by the recognition that there have been situations where governors have been credibly accused or found to have engaged in financial improprieties, and those governors have resigned. Financial improprieties that are quite analogous to what is at issue in this particular case. But I want to make the fundamental point that in Sauer, this court held that a preliminary injunction was not available to restore an officer. Sauer was a preliminary injunction. It's a preliminary injunction against the...
That's true, but weeks later in Drago, we permitted an officer who was still there to stay. So that was a case of reinstating someone. We have plenty of cases that say keeping someone in place who hasn't left yet is different than issuing a preliminary injunction.
I think the court's referring to the Delgado case, and in that particular case, it was a writ of mandamus to an inferior there, the clerk, to recognize the de facto officers when there is dispute about who had been validly elected to be the city commissioner or whatever the statute was. And this court said you can grant a final judgment in mandamus to say you have a ministerial duty to recognize the de facto officer. That is totally different than issuing a preliminary injunction. Keep in mind, there is no such thing as final mandamus. And in fact, Judge Friendly once described that as the starkest of solecisms. Sorry, there is no such thing as preliminary writ of mandamus. Judge Friendly described that as the starkest of solecisms. What this court held in Sauer is there is no jurisdiction to issue a preliminary injunction restoring a public officer to office. And that's a holding of the court.
She never left. She's still there.
She is reinstated. What the court framed its holding as, there is no jurisdiction over the appointment or removal of inequity of public officers. So it does not turn on whether or not she's sort of, stoutly staying in office or whether or not she's gone and then sued later. That it doesn't, nothing turns on.
General Sauer,